Deputy President. I rise on behalf of the opposition to speak on the Claim Farming Practices Prohibition Bill. This is a bill which will prohibit the practice commonly known as claim farming. It is an unethical practice engaged in by a very small number of legal practices and other persons to aggressively solicit persons to make compensation claims in tort. Even though the overwhelming majority of the legal profession behaves ethically and in the best interest of their clients and the community, it is appropriate to legislate to prohibit claim farming. It is a rare practice, but it is also an unacceptable practice and should be prohibited. Claim farming involves a kind of secret commission or undisclosed fee to the claim farmer. This is sometimes paid by a lawyer at the end of a claim against the vulnerable claimant. Claim farming occurs where legal practices or other persons actively solicit claimants, and there have been examples of the entire population of a prison being contacted and asked if they have a claim, and indicating to them that they may have suffered some tortious damage for which they can recover. Claim farming exploits often vulnerable claimants by exposing them to high-pressure tactics, including what are often misleading promises, to coerce them into lodging claims. Victim survivors of child abuse have been a particular target of this practice, and they have a significant risk of re-traumatisation and also incurring financial loss through these aggressive practices. There are a number of reports of the compensation available to victim survivors through the Civil Redress Scheme being deposited as part of the claim farming practice into a solicitor's trust account to cover fees on a separate claim with the promise of a higher damages payout. This may or may not eventuate, but any civil redress money is exhausted in the payment of professional fees, leaving the claimant with nothing but revisited trauma. Claims that are pursued for the benefit of claim farmers and unscrupulous lawyers can result in a costs order against the vulnerable claimant if the case is ultimately unsuccessful. This puts the claimant in a much worse financial position than they would have been in before being contacted by the claim farmer. Claim farmers also make extensive use of referral services. Adding insult to injury, the referral fee paid for the claim is often charged to the client as a disbursement, so the claimant is charged for the cost of the solicitor sourcing their business. Anecdotal reports indicate that claims can be sold to law practices for anywhere between $800 to $10,000, indicating the value of the new business to the claim farmer. Claim farming is also harmful to the administration of justice. In the rush to make claims, it is clear that a number of the claims made are fraudulent. Only last month, 7 people were arrested and charged over alleged fraudulent sexual abuse compensation claims, part of a claim farming scheme which targeted the New South Wales Education Department and has been alleged to be worth more than $1 billion. New South Wales Police alleged that claim farmers approached young former offenders, inmates and public school students, encouraging them to file fraudulent compensation claims for historic child sexual abuse while in care. Prospective claimants were coached on how to make fraudulent claims through various Sydney law firms. Apparently, 1/3 of the inmates at Cooma Correctional Centre submitted claims, all of which will now be investigated by the police, a number of which are thought to be fraudulent. So, this is a necessary bill which, as has been explained, will prohibit a person from contacting another person to encourage them to make a relevant claim. It will also prohibit a person from buying or selling a relevant claim referral. And I think importantly, it will prevent any lawyers who are convicted of these offences from charging legal costs in relation to the claim and require them to refund any costs that they have already received. This is appropriate, as solicitors should not be able to benefit financially from such claim farming practices. And of course, all parties will also be liable for criminal penalties. This bill will not prevent claimants from making legitimate claims, but it will protect them from aggressive and unethical practices. The bill contains a number of protections and exemptions for what we would regard as normal and legitimate activities, including the buying and selling of legal practices or the referral of clients to another law firm with more expertise in a particular area of work. The central element of the offences created by this bill is that consideration must flow for a referral. So this will not include the sadly all too common situation where at a barbecue somebody who is known to have legal qualifications may be asked for a bit of advice or a referral or somebody who could do the work. No payment is made for this type of referral, and so therefore it will not be caught by this bill. That's right. Only harmful and wrongful practices for undisclosed fees are covered by this bill. Claim farming harms often the vulnerable, but it harms our entire community because it incentivises litigation for commercial gain rather than for justice. It erodes public confidence in our institutions. It clogs our courts with speculative or exaggerated claims, and it exploits vulnerable members of our society. It can lead to inflated legal costs and to increased insurance premiums and the misuse of court time and resources. Individuals targeted by claim farmers may be misled into pursuing claims they do not fully understand or that are not in their best interests, often without informed legal advice. This bill aims to protect claimants, discourage opportunistic and unethical behaviour, and ensure our system is based on justice rather than exploitation. We are happy to support it.
Madam Deputy President.
Ms. Sue Higginson, sorry, she jumped.